Number 7, U.S. versus Gray. This is a quickie and one that scares the shit out of me. This is out of the 4th Circuit. What they said was the judge denies a suppression order. The guy then enters a conditional plea. He gets a sentence, and on appeal, the 4th Circuit says, well, we're going to look at the PSR, at the pre-sentence report, and we find some facts in there that weren't at the suppression hearing, and they support the judge's order. Duh! You know? I mean, think about this. You know, you've been at a sentencing. It's the most critical fucking stage, and it's 99% of our cases are pleas in federal court. The only time the guy ever gets to do anything is there at the sentencing. And do you get to crossing? You're sitting there, and somebody in a robe, you know, called a probation officer who usually has a gun, you know, under the robe, and who wants to be. They're wannabe cops. You know, they really are. And it's like, you know, flies on dog shit. Boom, every bad thing that could possibly happen. They talk to an agent who talked to somebody else, who talked to a third hand, and that just somehow gets into the PSR. And that's going to be evidence that they're going to base the suppression motion on? Well, don't read Rule 104 of the Rules of Evidence. It doesn't seem that the Rules of Evidence, I don't think you can complain about it being hearsay. What should we be complaining about? Crawford. It's definitely testimonial. It definitely is hammering the shit out of us. And we ought to be arguing that if you're going to consider that, in terms of my constitutional rights, you got to give me the opportunity to confront and cross-examine.